ahead and great. Thank you. All right, good afternoon, and it is Monday, March the 11th, and you are here for the Subcommittee on Family and Juvenile Law, and I'm Delegate Charlotte Crutchfield, and I am the chair of the committee. We're going to start out with our first bill, which is HB 214, and we are going to just talk a little bit about it. It is the bill that deals with the adoption of an adult, and specifically what it does is it no longer requires parental consent and no longer really requires a show cause order, and lets the judges have discretion as to investigations prior to rulings on adoptions. And the reason for this is really to deal with inheritance, fostering relationships, medical reasons, etc. So HB 214, and does the committee have any questions? We have as guests to ask questions. We have from DHS, Rachel Sledge. We also have Kelly Ray, who is impacted, and also Judge Jennifer Fairfax. And so does anyone have any questions regarding HB 214? All right, Delegate Valentine, lead us with your first question.
Thank you, Madam Chair. I just wanted to ensure that there has been no changes. I have not received any amendments since the initial hearing. Is that correct?
That is correct. There are no amendments to this bill.
Thank you.
Judge Fairfax, can you help us out just a little bit and just really explaining, are those the only differences right now as far as adoption goes when you're dealing with a minor versus an adult as proposed in this legislation, that it would only be, there would be no need for a show cause order, there would be no need for parental consent? Are there any other factors that are absent when you're dealing with an adult adoption?
So yeah, I think this covers those aspects as you indicated, meaning there would not be the show cause order. Adult adoptions are very different than adoptions of minors. And so speaking from my prior experience as a private adoption attorney for 16 years and having handled these actually across 3 jurisdictions, Maryland is currently the only jurisdiction between Maryland, DC, and Virginia that does not have a specific carve out for adult adoptions, specifically the ones that you have put in here, which is that you don't need the consent of the, I'm going to say formally legally recognized parents, because they could be adoptive or biological, as well as the notice. So that is like the major differences. And in the investigation, I mean, if it's contested, that could, the court would then be able to, with good cause, order an investigation. So it doesn't eliminate a judge's overall authority to ask for certain things. It's just about the notice to the legal or biological parent, as the case may be. In a lot of cases that I have seen, it may have been, as when I was there to testify before, a situation where the adult child had experienced abuse, but it also could be a situation where the adult child never knew or never had any information about their biological parents. May have been non-consensual conception, or they were never named. The biological mother didn't know. So again, these are reasons why when you require notice, it really is a huge extra lift and burden. And the court can, in my opinion, now sitting as a judge, kind of weigh all those factors and make a determination as what the right outcome is.
Okay, thank you so much. And so I think Delegate Kaufman, you were next, and then we'll go with you, Delegate Taylor, after him.
Yes, thank you, Madam Chair. And as I recall from the hearing, Your Honor, a lot of the reason that the witness, Rachel, I think her name was, wanted to have this happen was for emotional and mental health reasons, which is a reason enough for me to support it. But I just wondered if there are, and Delegate Crutchfield alluded to it, but if you could just spell it out for me, if there are any practical benefits, like when an adult adoption goes through that makes inheritance easier or taxes easier or something, besides the emotional, something on the practical side that it benefits?
Yes, absolutely. That's true. We did talk about that at the hearing as well, which is inheritance, right? So if an adult adoptee I usually try to start with this example, if an adult adoptee has children, and something happens to them, their parents may be the next in line or somebody who would step in or assist with those grandchildren. And if it is a parent to whom that adult adoptee doesn't have a relationship or doesn't want to have a relationship with those grandkids, that can be a very difficult position for everybody to sort of deal with that. There's also inheritance. When an adult adoption is completed, the child is treated for inheritance purposes as a child born to the person who adopted them. Now, there are some estate and trust things that need to be adjusted, like the definition of a child or whatever in the estate documents, but that is definitely there. And then the last thing, which we talked about, which I've seen come up in a couple of my cases, again, when I was a private practitioner, which is the duty to care for a parent who becomes indigent. So, that duty and responsibility could fall on a child who actually has no relationship or no desire to have a relationship, whether it is because of abuse or abandonment or neglect, or they simply just don't have a relationship with that person any longer, to then have them have the duty or responsibility to perhaps take care of that person. It impacts them greatly. So those are sort of the practical, more legal things that I've generally seen over the years.
Thank you, Your Honor.
Thank you. And go ahead, Delegate Taylor.
Trying to find my screen so I can get off mute. Thank you. I have a couple of questions, but really short. The first one is, how many of these cases are actually, or approximate, do we see in a year or, over time? And then how does that compare to the US?
So I'm not sure if I can answer how it compares to the US overall. I'm not sure I've seen that statistic. And I would, again, when I was in private practice, I was probably one of the, did more adoptions than most other people across the state and across the region. And I would say we were handling anywhere from 5 to 10 adult adoption cases on a monthly kind of rotating basis, right? So these can take 6 months to a year if it's contested over 2 years to get through. We were routinely having adult adoption cases come into the office. Now, didn't mean we filed 5 to 10, because oftentimes when we would explain to the adult adoptee that they were going to have to notify their biological or legal parents or get their consent, they would say, I don't want to do that. It's too easy or traumatic, or I don't want to, deal with that, or I don't want my parents to have to deal with fighting them, or, all of those kinds of things. So we would have that many that people would be seeking to do this. We would probably only proceed with maybe 2 or 3 of those on any given month. So in a year, it would be 24 to 36 adult adoptees that were having to deal with this, and probably closer to, maybe 3 times that would have done it, but for this piece of the law.
Right. And is there some process, and maybe this is the just cause piece of it, that, if I'm 18 and it's 18, right? Not 21, or is it 21?
It's 18.
It's 18. So if I'm an 18-year-old that is maybe just mad at their parents, like, or their birth parents, like, is there some way to determine whether this person really has a great reason to do this, or do you need a great reason to,
Yeah.
want
So
to be adopted by somebody else and not have to let your biological parents know?
No, yeah, thank you for that question. And again, I've seen that too, right? I mean, some of that is an attorney's judgment, in that, I know I wouldn't have taken a case if I thought it was being done for retaliatory reasons or because they were angry, but that's not what we're talking about. We're talking about people who bring those cases anyway. And I do think that is something that a judge does, right? At a hearing, asking the reasons for the adoption. Why do they want it to go forward? Sort of making that assessment. I think you leave that for a judge to determine, the why it is. Why should this adoption be granted? And again, even though it's the best interest as a child standard, it's still the standard within adoption. Is that the best interest of this person for this to happen? And what are their reasons? So I do think that is something that the court takes into consideration.
Thank you.
Right. And I have a question for Rachel Sledge. How, from the agency's perspective, how helpful is this for young people to be able to be adopted without so much paperwork or so much bureaucracy involved?
Thank you, of course. So one of the things that we're looking at this administration is to move toward permanency for older youth that have been in foster care. So 18 to 21 years old. At 21 years old, they age out of foster care. a bill like this would help find permanency and placement for those foster youth. They wouldn't have to seek out parental consent to be adopted, so they could, find family of chosen origin. And to some of Delegate Kaufman's point, this would then open up avenues of making sure that there is opportunities for inheritance and things of that nature, not just the emotional support, which of course is valuable, and not just simply having a seat at the table at Thanksgiving or Christmas, but to also have some of these more legitimate things. The other thing that we're looking at here specifically with 214 is we actually have a bill in front of Judiciary tomorrow on changing the definition of kinship caregiver. And these bills would pair really well together in helping us advance, making sure that our older youth, which are less likely to find adoption and permanency and placement because of their age, would then be able to find chosen family through kin and others that they have deep bonds with already in their community. So that's really what we're looking for. We see this bill as helping us advance the goals of this department in making sure that more foster children and older youth, which is 18 to 21, would actually have permanency and a family.
Thank you very much. Does the committee have any other questions for our guests? Okay, I don't see any. So thank you very much for attending and helping us with this. Judge Fairfax, Ms. Ray, and Ms. Sledge. Thank you so much.
Thank you, everybody. Have a wonderful afternoon.
You too.
Thank you.
Okay, committee. It looks like we're ready. We might possibly be ready to vote on this.
Yeah. I move favorable, Madam Chair.
Okay, is there a second?
Second.
All right. All right, so we will go ahead with a voice. I think we'll take a voice vote on this. So we'll start out with Delegate Bartlett.
Yes.
Okay, Delegate Boucher,
Yes.
Delegate Kaufman.
Yes.
All right. Delegate Pastor, not here. Delegate Sample Hughes, not here. Delegate Simpson, not here. Delegate Simpson.
Yay. Yes.
Okay, sorry, I meant Simmons earlier. Sorry. Delegate Taylor.
Yes.
All right. Delegate Tomlinson.
Yes.
Okay, and Delegate Valentine.
Yes.
All right, and I'm a yes too, so that is unanimous. All right. Moving on, our first vote out of committee today. Moving on to HB 508. And let's go ahead and bring in our guests for that. Delegate Embry, Delegate Embry, Miss Sledge, Melanie Shapiro. Okay. Hello, Delegate Embry.
Hello.
All
Sorry, I'm on my phone.
right. All right, let's see. Is Melanie Shapiro? Yep. No, wait a minute. Let's see.
I'm here.
There you are. Okay. All right. Okay. And Stephanie Porter. I'm not sure.
I'm here. Good afternoon.
Okay. And who are you with, Stephanie? Because I don't have you on my list.
I'm a judge at the Circuit Court for Howard County. I was asked to sit in
Perfect. Okay.
our committee, I believe.
Representing the judiciary on this one. Okay. Perfect. Okay. So, Delegate Embry, will you give us a very, very short synopsis of what your bill does?
Yes, thank you. And this was brought by advocates like Melanie Shapiro because when labor trafficking was created as a new crime in Maryland, there were a few places where it didn't show up, including the family law, and then also making sure that it was tied to the regional navigators. So this, very basically, this law is meant to address, just make sure that labor trafficking is fully embraced in our law in the places that sex trafficking is.
Okay.
And we have, well, I'm sorry, I understand there were some amendments on the Senate side, but counsel for the committee may be more up to date on exactly what those are.
Yes, and we do have amendments, and I think everybody should have copies of those. Let's see, and Lauren, do you want to go through those?
Sure. My understanding is that the Senate didn't act on this yet on their side, but I have Delegate Embry's amendments that are 53326/1. And very simply, they just add labor trafficking to the definition of abuse in the provisions relating to child in need of assistance and child abuse and neglect. And it's similar to the way in which sex trafficking was previously added to those definitions of abuse.
Okay,
Madam Chair, if I may.
sure, go ahead.
Thank you. I noticed in neither amendment, they are very similar. It's supposed to add in by any individual so that the labor trafficking doesn't need to be by a parent or legal guardian, but it mirrors what sex trafficking has. And that language is by any individual. And I think it's where it is. I have to flip my screen to see what exact page, but it's where it is letter P in terms of the definitions. And I believe that was DHS's request. And I see Ms. Sledge is on here and affirmatively nodding.
And Delegate Crutchfield, I can simply add that in both places to make those consistent. It wasn't how the amendment was drafted, but I agree that now it's inconsistent if we don't put that. So I think we should add labor trafficking by any individual in both places, the family law and the child in need of assistance. That would be just a little amendment to that amendment.
Okay. All right. Are there any questions by the subcommittee to any of our guests present? Okay, I have a quick question, and it probably will be best answered by you, Ms. Shapiro. Can you really just explain what labor trafficking really is?
Yes. So labor trafficking is when an individual, by force, fraud, or coercion, is compelled to do some kind of act. When the most traditional way of thinking about labor trafficking is in the context of some sort of physical manual labor, or any other kind of labor. And, you know, I've talked to many of you about this bill and explained the distinction. So there are labor laws and there's violations of labor laws. And this is separate and distinct from that. The primary distinction being the force, fraud, or coercion. So there are many laws as it relates to children in terms of what kind of work they're allowed to do, the number of hours that they're allowed to work, and conditions. None of that is impacted by this. There are separate laws and separate penalties for that. But labor trafficking in Maryland, so the way that we're seeing it, there is farming, and they're doing labor trafficking. It is coming up in different industries like, nails and massage parlors. We have Ocean City, and so you'll see labor trafficking there, especially in the summertime. And it's somebody generally is brought in under some sort of false pretense. And, in the adult context, sometimes it's the theory that, somebody comes for, the reason why M&ADV is so involved is they come for love. And they think it's a relationship, and then they are in fact exploited. And so that's sort of a summary of what labor trafficking is. In sex trafficking, the trade is the sex. In labor trafficking, the trade is the labor. If you're, looking for a comparison.
Okay. And with this bill just really adds in to the section of the law dealing with Safe Harbor, right? Regional Navigator Grant Program.
Correct. So right now, as Delegate Embry discussed earlier, labor trafficking was only made a crime in the state of Maryland just not that long ago, really around the time we started initiating Safe Harbor legislation. And so it is not recognized as a form of child abuse or neglect to labor traffic a child. And that is one of the mechanisms needed to refer a child to the regional navigators who were specifically designated to provide services for child victims of sex trafficking. They are capable of absorbing the child labor trafficking victims as well without with current resources. They're not seeking any additional resources, and they have the knowledge and the expertise to connect the children to the necessary services, along with DHS and the local DSS agencies. They work,
Okay.
very closely together.
And there's a reporting mechanism as well.
Correct. Correct. And so right now, quite frankly, labor trafficking is it's not often identified. And one of those reasons we think is that because it's not part of the abuse and neglect statute. So like teachers, for example, are not required it's not a mandated report. And so now we might hopefully identify some more children and get them connected to the necessary services. And this is the mechanism needed to do that.
Okay. All right. Are there any questions by the subcommittee? Okay, I don't see hands going up. So I think then that will be all we will have from our guest, and we appreciate you guys being here. Thank you so much. And Judge Porter, I guess nobody has questions. So thank you though for being here.
I think that one of the concerns that we raised, I'll just highlight, is what I believe I heard the change to be, we were worried about inconsistency in the criminal law definition with the definition in this article, which created a different definition of labor trafficking. Because in this statute, it would keep it at a child, limit the definition to a child versus the criminal law statute, which indicates another, I think, or the specific language. So we were worried about the inconsistencies in that.
Yep.
Okay.
Delegate
Thank you.
Crutchfield, if I could just explain.
Sure.
that.
Go ahead.
So the entire definition, aside from the addition of the word child, is identical. This is this is adding it to the abuse and neglect statute, which is unique to children, which is why the word child is added in there to be consistent with DLS drafting and the rest of that section of the code, which only applies to children under a certain age.
Okay, got it. Okay, any other questions? Okay, well, thanks again for being here, Judge Porter, Ms. Shapiro, Ms. Sledge, and of course, Delegate Embry. Thank you.
Thank you.
All right. So let's talk about this a little bit. Do we have a motion on the amendment? And once again, I apologize, but Lauren, would you go ahead and recite the amendment with the added amendment to it? So
Sure.
everybody's clear on what we're going to be taking up.
Yes, the amendment would add labor trafficking by any individual to the definition of abuse in child in need of assistance provisions and child abuse and neglect provisions.
Okay. All right. Do I have a motion on that amendment?
So move. I move favorable.
All right, is there a second?
Second.
Okay, any discussion on it? All right, not seeing any, so let's go ahead and take a hand vote. So everybody in favor of the amendment, let's go ahead and raise our hands. Okay. I think that's everybody.
Does
All right.
does Delegate Taylor have a question, or she's raising her hand?
She's raising her hand, I believe. She's raising all of her hands. All right. And let's see, let's go ahead and, is there a motion on the bill itself with the amendment?
Move favorable.
Okay, is there a second?
Second.
All right, is there any discussion? Any further discussion? Okay, not seeing any, and I don't know why my hand is raised. But anyway, not seeing any. Let's go ahead and take a roll call vote on it. Delegate Bartlett, Vice Chair Bartlett.
Aye.
All right. Delegate Boucher.
Yes.
Delegate Kaufman.
Aye.
Delegate Pastor.
Aye.
Delegate Sample Hughes. Don't see. Delegate Simmons. Don't see. Delegate Karen Simpson.
Yay. Yes.
Delegate Taylor.
Yes.
Delegate Tomlinson.
Yes.
And Delegate Valentine.
Yes.
Great. And I'm
I
also
think Delegate Pastor is here too now.
Yes, she is here and she voted.
Okay, cool.
We're good.
I'm here.
All right. Thank you very much for that one. And that's our second vote out. Our next bill up is HB 542. And we should have Delegate Vogel, I hope, in the room coming in shortly. No, it's 542, not Delegate Shetty. Okay. Let's see. I don't see Delegate Vogel. Is Delegate Vogel here or around? Not that we really need him, but
Should I text him, Madam Chair?
no, that's okay. We've also got Rachel Sledge, so that's fine. Okay, let's go ahead and move forward with that. So this was HB 542, and this is the Department of Human Services Children in Foster Care Luggage. So I'm assuming everyone received a copy of the new policy that the Secretary of Department of Human Services, Secretary Lopez, put together. Did everybody receive that last week? And the effective date was the 5th. I think we got it on Monday, and then the effective date was the 5th. Everybody's kind of, did you guys all get it?
Yeah.
Okay. All right. Okay. So what that policy does, I'll let Ms. Sledge just briefly tell us what how the policies really is going to relate to all of the different 24 jurisdictions and what comes next.
Thank you, Delegate Crutchfield. So as Secretary Lopez had spoken to y'all regarding sort of the order of events, right, which was that as this bill was introduced and as he began to ask questions of the local department, he was able to discover that, in fact, all of our local departments do have currently on-premise new luggage, either suitcases or duffel bags or as well as backpacks that are currently on-premise and available to the local directors. But then as he asked more specific questions about operation procedures and policy, he discovered that there was not a formal policy in place with regards to the transport of children's belongings in appropriate vessels. And so, within a few days, had a policy drafted up. And so what you'll find in front of you is actually what went out to all 24 local departments of social services. It is now the official directive from the Office of the Secretary as to how children's belongings may and may not be transported, not just when they come into care, but also when they're transported between placements, and also when they exit foster care, to make sure that children's belongings are respected and treated with care, and that the children themselves are treated with dignity and respect. And we had heard on the Senate side very moving testimony from a young woman from Frederick County who had experienced her belongings being placed in a trash bag, and she voiced that this actually made her feel as if she was discardable. And so it was very moving testimony. I just bring that up to say that this policy is now formal and in place and in practice across the 24 jurisdictions. You'll see in the policy there's also standards for what will happen if it comes to the attention of supervisors, the local director, or even the Office of the Secretary that a child's belongings have been transported inappropriately. And so the goal, of course, of this secretary is to ensure that this doesn't happen again, not under his watch and not ever. And so this is something that we want to move toward. Now, the policy itself, I've talked actually to some of the local directors, and they were just sharing with me the way that they even partner with their local board of social services, which is governed by under COMAR, and the way that they partner with other nonprofits and local organizations to make sure that they have luggage available to them. So that's what they're doing at the local level to make sure, which I know the bill specifically states that the department's able to get luggage by accepting gifts, donations, grants of any kind. And so that's actually something that's already happening in practice. So with that, I'll open it up to any specific questions you might have about the department's current practice or what our position is on the subject matter.
Thank you very much, Ms. Sledge.
Mhm.
Are there any questions from the subcommittee? Let's see, I'm not seeing any. Okay, all right. Then thank you very much, Ms. Sledge, for being here. We do appreciate you very much for coming. All right. Yes, go ahead. Do you have a question for Ms. Sledge?
Yes,
Okay.
I just came a little late.
Okay.
But Ms. Sledge, have you talked to Delegate Vogel about the list, and is he satisfied that that takes care of what he was trying to accomplish in the bill?
I have spoken with Delegate Vogel. We met last week. He very much is pleased with the policy. It is his position and his Senate cross-file sponsor that they really feel that this does still need to be codified. That's not really, that's the decision of the lawmakers. We're trying to respond in the moment and do what needs to be done. And we do feel that the policy that we have is going to dramatically alter what happens under the department. Now, there's other organizations and other agencies that are a part of this process as well. And so, we don't have any authority over them or ability to control some of what their actions are. But this certainly, it's our belief that the policy does address the concerns of the bill, but Delegate Vogel very much feels that it needs to be codified.
Okay. Thank you very much. Any other follow-up on that, on Delegate Kaufman?
No, thank you, Ms.
Okay.
Sledge. Thank you, Madam Chair.
All right. Thank you again, Ms. Sledge. All right. And once again, Council, I think you're going to have to help us because there are amendments to this as well.
Okay. So the amendments that Delegate Vogel submitted would conform the House bill to what passed out of the Senate. And they would they clarify that new luggage for a child in foster care does not include trash bags. They expand the circumstances under which the department must provide new luggage to a child in foster care. So it's when the child is entering foster care, moving from one foster care placement to another, or exiting foster care. The amendments require the department to take into account certain factors when providing the new luggage, which is shown in number 4 on your amendments, which is the child's age, mobility, personal items to be transported, and preferences. And the amendments prohibit the department from using disposable bags or trash bags to transport any items of a child in foster care.
Thank you so much. Okay, do we have any questions? And what we'll do is go ahead and can I get a motion on the amendment?
I move the amendment.
Thank you. And a second? Thank you so much. And is there any discussion on the amendment? Yes, Vice Chair Bartlett.
Thank
you. Yep, you're on mute.
There we go.
There.
Okay. So I appreciate Delegate Kaufman's question. It was a question I was floating around. So I'm glad you asked it, Delegate Kaufman. It seems that while I can appreciate what the new policy is, and I like it, I'm concerned about the partners that Ms. Sledge mentioned. And if we codify the language, we would actually we would hit, I think, everyone. I was trying to look at the bill really quickly to see how it's worded, but I think it would take care of anyone who is in the who fills the role of foster care or the transfer of foster care children. And perhaps someone could clarify if that's correct, that the bill would help at least mandate that this is the new method.
Okay. And Lauren, are you able to do that for us?
Well, it would codify. Yes, it would. Now this would be, I'm sorry.
No, go ahead, because
yes.
I'm looking at it and it says the department shall, and I just want to make sure that it would, handle anyone who participates in the foster care system who may not be directly in with the department?
Well, it would just be for those children over whom the department, I believe, would have, and Ms. Sledge can correct me if I'm wrong, but I think it's for the children over whom the department would have supervision or responsibility in some way.
Right, or are we not understanding your question?
You're
Right,
understanding
maybe
my
not.
question. I just wanted to see if Ms. Sledge could, because she mentioned that in when she was talking, she was saying that it didn't have, that her policy doesn't necessarily control their partners. And so I want to see if she feels that the bill, and I'm not trying to get you to talk towards the bill, because like I said, I know you did the work of the policy. But with respect to partners, how about this? I'll do it this way. Can you clarify what you meant by partners? Who are the partners?
And
Absolutely.
before you answer that question, can we get Delegate Vogel is in the waiting room, if we can bring him in.
Great.
Okay. All right.
I'll wait for Delegate Vogel, but then once he comes in, Delegate Bartlett, would you mind just repeating your question so he knows where we're at in the conversation? That would be helpful, I think.
Sure, no problem.
I'll say.
There he is.
I was gonna say, Joe just said he came over because he was locked in the waiting room.
All right, Delegate Vogel, we have a question we hope you can help us with. And go ahead, Vice Chair Bartlett, did you want to go ahead and?
Sure. So my question was, I know that we have new policy with respect to DHS, but I wanted to know if this new policy would also have some control and effect with the partners that DHS partners with, because Ms. Sledge mentioned that the policy obviously affects the department, but they don't have control over the partners. And so that was my question.
Thank you. So with respect to the policy, that policy is just directing our local departments of social services and our social workers, our caseworkers, when they are the one directly overseeing the intake and then the transport of a child in care. It does not have, our policy doesn't have any authority over any of our partnerships, and it doesn't have any authority over other agencies with whom we share children. So that would be, for example, there are some children that we share with Department of Juvenile Services. In which case, the policy is an internal departmental policy. With respect to the bill, the way that we read this and the way that we interpreted this is similar, that the bill is under our section of code and it strictly regards the department as an entity. Now, what the secretary wants to do with respect to our organizational partners, partners like Bethany Christian Services that do foster care and do some of the casework and transportation, that, for example, across the state, but others as well, is that we would just have to make sure that they understand in our contract with them what the standard and expectation is about how they would treat children's belongings while partnering with us in that endeavor. So that's a change that he's looking at, but the way that we look at the policy and the way that we look at this bill, we don't believe that those inherently have that authority to dictate how those other organizations would function.
And do you want to add anything, Delegate Vogel?
Yeah, and thank you, Madam Chair, and apologies again for the delay. I would say, I'm very, I really appreciated the engagement with Rachel and your team, and appreciate the fact that you all are now going out of your way to ensure that this policy is reflected in contracts with those you contract with. I will say, and Rachel, based on our conversation as well, codifying this is going to ensure guarantee consistency going into future administrations and ensure compliance with this policy. And I know that we also requested to keep that provision in there around reporting, which I think is also really important because that'll give us adequate data and moving forward will give us a sense of whether this is continuing to happen either with the department itself or with its subcontractors.
Okay,
I find, Madam Chair,
sure.
I find this discussion very helpful, but I also find it to present somewhat of a whole. And that is, I'm very concerned, and perhaps we'll take it up next session, Delegate Vogel. But I'm concerned about those individuals who are not covered under the bill, that DHS may partner with, or other departments that are not covered under the bill, such as DJS. If the goal is to make sure no child is being transferred by a trash bag, I kind of would like to take care of achieving that goal. But with that said, this is an important bill, and I don't want to, I don't know that I necessarily want to stop this particular bill because of it. I could enter an amendment, or you know, if the sponsor would treat it as a friendly amendment. These are just some thoughts, and this is our work time. So Chair, I appreciate you indulging me.
Yes, no problem. And so with that said, is that something you're interested in, adding an amendment, or do you?
Well, I'd like to hear Delegate Vogel's response to see just if he would take it as a friendly amendment, or just you know, before I put in an amendment.
Right.
I'd be more than happy to take that as a friendly amendment. And I'm happy to work with you offline, Delegate. I think there's a pretty simple amendment that we could add in there to expand this to the department, and we can figure out the appropriate language. But other subcontractors and other agencies that might be dealing with children in the foster care system.
Great. Collaboration is key. Thank you so much.
So let me ask counsel for the rules on that, because if it is an amendment that we can actually put together right now and add, then it might be achievable to do that. And I'm assuming we can. And what do you think about that, Lauren? Are we able to do that? And have you, as you're listening, thinking about a sort of quick fix on this to add in subcontractors and others who may have, I guess, control, or I'm not quite sure. What do you have in mind, Delegate Bartlett?
Yeah, subcontractors, and I believe I heard Ms. Sledge mention the Department of Juvenile Services, because they also work with the transfer of children. I don't even know what their policy is, though. So, and I have to go back to Delegate Vogel to see if in generating this bill, if he found out anything with respect to DJS. Is this, you know, or is it merely DHS that we were concerned about with this particular policy?
Delegate, I would say we were concerned with DHS and those that they contract with. If possible, Rachel, if you're able to chime in there, I'm not too familiar to what extent DJS is engaged here. Madam Chair, I don't want to call on someone else here, so defer to you on your protocols here. But I would love to hear from Rachel on that piece.
So yeah, and I think what I'm also thinking is that DHS is the umbrella over this. And so therefore any subcontractor, I mean, in the world of contracting, will come under that. And therefore whatever DHS has as a requirement, that subcontractor, it flows down to them. So that's kind of what I'm thinking or reading. Would that be possibly the case as well?
Oh, sorry.
Go ahead.
Go ahead, Delegate.
I was just going to ask whether we could potentially introduce an amendment codifying the what we had discussed, Rachel, around ensuring that as you are establishing new contracts or reviewing contracts, that you ensure that there is a policy in place for subcontractors to not be distributing trash bags. Is that something that you could see us codifying into law? I think that would address the contractor issue.
So I think this would be this is a very interesting conversation, because as I'm thinking, I'm to Delegate Crutchfield's point, I think in order for the Department of Human Services to fully abide by and be faithful to law, we would have to ensure that anyone that we contract with abides by the same standard. Otherwise, we would be out of compliance.
Right.
So I don't see a need to codify that there. I think the department just needs to do what needs to be done to make sure that those individuals understand the policy. With respect to, our sister agency, the overlap is sometimes that a child comes into our care and then ends up in the care of juvenile services, or vice versa. And so how, depending on how that works, and sometimes they're sort of like co-assigned, we really want to probably engage DJS on that. But that being said, that's a very small population of children every year. And so I think, if we want to move forward this year, we would capture the majority of children entering into care and being transitioned between placements. And then still get Bartlett's point, perhaps come back in a future year and address to make sure that this is happening with, children who are in other places of care.
Well, it also seems to me that the focus really is on DHS and what's happening in the foster care arena. So, and I do believe DJS would be outside of that. But if they sometimes have the coexistence together, then obviously the child will get a luggage bag, because they would really be under both. So it almost seems like it would happen anyway. That a child will get the luggage. So, okay. And I think,
Thank you.
Yeah. And
I'm satisfied.
Okay.
Thank you very much.
Okay. All right. So we were on the motion and
amendment,
at a first and a second. I'm sorry.
The amendment, I think, yeah.
I'm sorry. Yes, it was an amendment on the motion. So we had a amendment. We had a motion on the amendment, first or second. And so all those in favor of the amendment, please raise your hand. Okay. And those opposed? Anybody opposed? Okay. All right. So we have the bill and the amendment. Do I have a motion on the bill and the amendment?
Move favorable on the bill, but I'd like to say something if I could.
Okay. All right. Just a second. As soon as I get a second on it. All right.
Second.
All right. Now you may speak, Delegate Kaufman.
I feel very strongly that while I appreciate the work of Ms. Sledge, I feel very strongly that we need to pass this out of subcommittee, because administrations change. The policy can easily be rescinded. So we need to ensure that we are protecting kids regardless of who is in office. And I don't doubt, Secretary Lopez's sincerity, but he won't be secretary forever. And so I'll be proudly voting yes for this.
Thank you. Any more discussion on the amendment? Delegate Valentine.
Thank you, Madam Chair. And if I could just for 1 second reiterate Delegate Kaufman's comments with a me too. It's exactly what I was thinking. Thank you.
All right. Great. Thank you. Any other me toos? Otherwise, let's take a vote. Oh, Delegate Taylor, do you have a me too? No? You just ready to vote? All right. All right. We're going to do a quick roll call vote on this, starting with Delegate Vice Chair Bartlett.
Yes.
Delegate Boucher.
Yes.
Delegate Kaufman.
Yes.
Delegate Pastor.
Yes.
Delegate Simpson,
Yes.
Delegate Taylor,
Yes.
Delegate Tomlinson,
Yes.
Delegate Valentine,
Yes.
and myself, and that's unanimous. Great. All right, let's move on to our next bill, and that's HB 745. Thank you very much, Delegate Vogel and Ms. Sledge. I think, let's see. Nope, you're not on this one. Thank you. All right. HB 745, and we have Delegate Shetty. So Delegate Shetty, last time we were here, we were learning about your amendment. Could you once again just describe to us what the amendment to HB 745 does?
Yes, Madam Chair. Thank you all for having me back again. The sponsor amendment moves all of the original changes we were seeking from the protective order into the peace order section of the.
Delegate, I'm having trouble hearing you.
Oh, Delegate Shetty, I think there's something wrong with your sound. I don't think she can hear us. Uh-oh. Let me text her. Hold on. We can't hear you. Yeah.
Well, we did. We only had one person that I went through before.
Yeah. Could you also bring in Melanie Shapiro into this bill as well? Great. Let's see. All right.
Madam Chair, Delegate Delegate Shetty said she's going into her phone.
Got
just
it.
to let you all. Yep.
Okay, great. Thank you. Okay. So Melanie Shapiro, while Delegate Shetty is coming back on.
I'm back. I'm
Oh,
so
great,
sorry.
great. Okay, yes.
I'm sorry. My state laptop is malfunctioning. Its mic is malfunctioning. I apologize. So what the amendments do is it moves from the protective order into the peace order, all of the protections we were seeking for non-intimate partner victims of stalking. So extended.
Hold on for 1 second. I'm gonna let in Lisa Jordan, who's also here. Okay.
Thank you.
Okay, keep going, Delegate Shetty. Go ahead.
Thank you. So the sponsor amendments would allow for a non-intimate partner victim of stalking to apply for a peace order that would have the same length of duration as a protective order. It would authorize or provide discretion to a judge to remove firearms from dangerous stalkers, and it would create a pathway towards permanent orders that is accessible to peace order victims of stalking.
Okay. All right. Are there any questions by the committee regarding what the amendment does? Everybody clear on that? And I'm sorry, did you describe the details around the permanent pathway that's in both, for both protective orders and peace orders? Anyone can do that if you don't.
I did not, but I can pull up the language unless somebody else.
Yeah, someone else can do it if they Ms. Jordan or Ms. Shapiro.
I would defer to Ms. Shapiro on this one.
Okay.
So I am pulling up the specific language
okay.
for the amendment, but right now in order to get a permanent protective order, the abuser needs to have been convicted of a crime, and then sentenced and served, I believe, at least 2 years of that. And so there are situations in which victims have been able to get a permanent protective order, but they're very few. And not many of them, I believe, are actually victims of domestic violence, which ends up in an assault category. that doesn't end up with a sentence that meets the requirements. I would think that Ms. Jordan, in her experience, it's more of the sex assault victims where there are more criminal convictions are able to access that relief. And so this improves the pathway for victims of domestic violence in the permanent protective order. I do have the language pulled up.
But it will be it'll be the same language in the peace orders as well, correct?
Generally speaking, and also
Conviction
to
of a
clarify,
crime, also serving 2 years.
so right now there's no ability to get a permanent peace order
Right,
whatsoever.
right, but we're adding that now. The
This
language
would
from the
create, yes, a
protective order.
pathway for a victim
Correct.
under a peace order to get a permanent peace order.
Mhm.
And I would also note that it's not for all of the relief eligible in a protective order. It's to the do not contact language and do not abuse. It doesn't apply in terms of some of the other forms of relief that are eligible in a protective order. It's limited in nature in terms of the permanency. And I'm just scrolling through to find the actual
Okay, that's fine.
language.
Yeah, I just wanted to get an idea of what it was exactly. Okay. Does anybody else have any questions? Okay, Delegate Valentine.
Thank you, Madam Chair. My question's specific to the firearm surrender provision. I compared this with what's in the firearm surrender for the protective order, thinking they would be very similar, but they are not similar. And I'm kind of curious as to how the wording in this particular bill was crafted or designed. And I have specific points I have questions about as well.
So
I could
Uh-oh.
start if
Delegate
helpful,
Shetty.
and then I can defer to some other. Can you hear me again?
Yeah, you're kind of breaking up a little bit.
I'm sorry.
It's okay. It's okay. So
Remember when we
Ms.
used to be-
Shapiro or Ms. Jordan may be able to answer that for us.
Sure.
Would you
okay.
guys, would either of you like to go ahead and answer?
I'm happy to answer in terms of the final order protection language that generally there is federal law on the civil side regarding domestic abusers being required to surrender firearms. Maryland's law has, been the same for a while, that pursuant to a final order of protection, there's a mandatory surrender of firearms. Under the peace order, because it's more of a fact-based scenario. Not every case is going to require the relinquishment, whereas in domestic violence, there's extraordinary amount of evidence regarding the lethality connection between the presence of a firearm and lethality in domestic violence. In fact, in Maryland, our numbers range between 74 and 76% of all domestic violence homicides are a firearm is the mechanism used. So that is why, but in the peace order context, it's a discretionary, it's a may, not a shall. Which is the may is also in an interim and temporary order or temporary order protection. The court has the authority to remove the firearm, but it's not a requirement.
I
Go
understand.
ahead, Delegate Valentine. You had some follow-up questions?
Yes, the may and the shall. What I'm looking is the criteria. So for example, the endanger public safety part, which would be number 2 under section 4. And I'm thinking, how is endangering public safety specific to a petitioner? That seems very broad to me. Endanger public safety as being used as a factor in a surrender of a firearm.
Can I speak to this briefly?
Yes, you can.
Okay.
Shetty.
Thank you, Madam Chair. Thank you, Delegate, for the question. So some of the circumstances we were contemplating here were cases where, for example, a stalker is pursuing their victim in like a grocery store or something, right? Or is following them around in other places that carrying a firearm into these places in pursuit of the petitioner could endanger public safety. And so that's like one example of the type of incident we were contemplating with this language.
Okay.
So what are the guardrails exactly around it? I apologize, Delegate. I'll let you go ahead with your question next, but what are the exact guardrails around the firearms piece? What are the requirements?
So under the amendment, the judge would have the discretion to remove firearms if the respondent would likely use it to cause harm to the petitioner or endanger public safety. There's also a rebuttable presumption that it would be ordered to be surrendered in the event that like certain acts were committed. So for example, the act that led to the issuance of the peace order is like falls under a specific section of the criminal law article. I think these are the crimes of violence. And then a firearm was actually used or threatened to be used in that act. So we've had, cases like the one that was raised by my constituent who brought this idea to us. She was a non-intimate partner relationship with her stalker. And he was, I think, driving to her house with a carload full of guns and ammo, planning to kill her and her family, right? So this is not specific to the petitioner, but to others who are related to the petitioner as well. And then the other rebuttable presumption is that the respondent has violated any prior peace or protective orders. So again, this would be a rebuttable presumption that the firearm should be removed under any of those scenarios.
Okay. And Delegate Valentine, you had some follow-up questions?
I did. Thank you, Madam Chair. And I'll touch on that first, since that was just spoke upon, was the prior peace order, a violation. When you speak of that, does that mean a conviction or an allegation, or someone has filed charges? I'm trying to determine, what does that constitute? Violated a prior peace order.
So under what we were contemplating here is in the event of like an individual has a peace order against them, by the respondent, for example, respondent and petitioner have peace orders, then if like a violation of like a prior one that had expired had occurred, then that's a scenario that we're looking at.
But I'm trying to determine what's the definition of a violation. Is it an allegation by the petitioner? Is it a charging document? Is it a conviction of it? What would that be? What would the definition be?
I don't know. I don't know if this is already defined in the code somewhere. I don't know the answer to that.
Okay.
Lisa, do you or Melanie, do you have any thoughts on that?
I do. Generally, I would think that a violation would mean a violation that had been adjudicated. But certainly if you want to clarify that, that is a criminal charge to violate a peace order, to violate a protective order. And it does seem, to the extent that this is vague, that would clarify that. I also will say I'm not confident I have an up-to-date copy of the amendments, but I'm not sure if there are ands or ors, if there's confusion in the ands and ors.
I was looking at that as well for numbers 1, 2, and 3 under, I think it's under number 2 for under the rebuttable presumption. Would those all be ands? Because one is a colon, then there's an and. So would it be all 3 of those, or how that would work?
I think we were contemplating that being an or, not an and. It says and on the copy that I have.
That's what I have, is an and between 2 and 3.
I think if there is an and, then it would be a very narrow, limited set of circumstances that would apply here. And I think what we were contemplating was that this should be an or. This might be an error in my submission to council.
The only other question, and I kind of go back to my first question, Madam Chair, was it seems like we had good language in protective orders that was very specific, threatened, used, or implied, and this seems to go further than that. If I don't know if that's a question or just a statement. For the removal of firearms in domestic violence, it's very specific. where this is a little bit more broad.
And again, is there an answer to that? I guess I thought that we were kind of lifting pretty much the language from protective orders to peace orders, but it doesn't sound like in this particular case. And as Delegate Valentine mentioned, or has also made clear, it's a different language. Is there a reason, or is that an oversight, or, you know?
Melanie may have spoken to some of the policy rationale in her earlier statement, but if the subcommittee feels strongly about having parity in the language, I would not oppose that.
Okay. All right. Any other committee members regarding the language in the specifically on the firearms piece? Okay. All right. Any other questions, concerns? Okay. All right. And let me make
Madam Chair, if I may,
sure.
I just want to make sure that the language that if there is parity, that we're keeping the protective order language intact, because that is just extraordinarily important for victims of domestic violence, so that if there's any change in the language, it's done to what's being changed in the draft bill, but that the protective order language itself is not being altered, especially around the firearm.
Yeah.
Okay.
I concur completely that I apologize if I created confusion here. What I was meaning to say is that if the subcommittee chooses to have parity in the firearm language with the protective order, that we amend the sponsor amendment to line up with the current protective order law around surrender of firearms, if that's the direction the subcommittee wants. That's what I intended to say. Don't change the current protective order law, change this amendment.
Okay, thank you. Yeah, that was what I understood. I mean, I understood that the original sponsored amendment was about keeping parity with the language from the protective order going into the peace order. So I was a bit surprised to hear from Delegate Valentine, and thank you very much, Delegate Valentine, for really reviewing this, that the language on the firearms piece was different. And it sounds like, and I guess, again, I'm not quite clear if that was language we actually wanted to change, or was that just something that might have been an oversight in the drafting. I just wanted to make sure I was clear on that, on how the language changed.
Thank you for that question, Madam Chair. So I think the original intent was to create parity. It still is the intent to create parity.
Okay.
I think we maybe made it a little more complicated once we started drafting this than needed. And so I would support the direction of the subcommittee in it sounds like you all are seeking potentially to just maintain the current protective order language and copy it over here. I think that's a wise move. So forgive me for my oversight.
Oh, sorry. Excuse me, Delegate Crutchfield. Yes. May I ask a question just for the subcommittee to consider if they do want parity? What Delegate Valentine is speaking about, I think there are criteria for the temporary protective order. And, you know, it's the use against a person eligible for relief, a threat to use it, serious bodily harm, things like that. But when you get to the final, it's a shall, it's mandatory. And so the subcommittee needs to, if you do want parity, just know that that would mean that for every peace order, every final peace order would be the surrender of firearms. There wouldn't be criteria. So I just think that's something the committee needs to be aware of.
So that is the reason why there is a difference. Okay.
That may be a reason why they were crafted differently. I don't know the background. I was just given the amendment, but I do want to point that out that
thank you.
That's something that's a big policy decision for this.
Right. And so I based on that, I'm assuming that's not going to get Delegate Valentine comfort in knowing that it'll be a total surrender.
Madam Chair, there is a significant difference between a temporary and a final in both sides. So I mean, I would certainly like to look at it first, but yes, I just like the language in protective orders because it's been around for so many years. It's tried and true. And this wording just was somewhat different to me. Very, very broad.
Okay. Yeah, so then the finals and protective orders are the same way then, is that correct, Lauren? That
Right.
is the surrender?
So the final, it's just the final protective order shall order the surrender to law enforcement of any firearm in the respondent's possession and refrain from possessing a firearm for the duration of the protective order.
Okay.
So that would, if you do that, that's fine, but that's what it's going to read for the peace order.
Mm-hmm.
It won't be the criteria that are listed, so.
Right. Okay. Okay. All right. So then I think what we should do is hold on our motion right now on the amendments regarding the total amendment, unless anyone else wants to comment on it from the subcommittee.
May I ask a question?
Sure.
Sorry. I know I'm not on judiciary anymore and this is wildly inappropriate. I apologize. I miss you guys just too much. Would you all be able to do an oral amendment on the firearms section and then vote on the rest?
Yeah, we can always do an oral amendment.
Okay. I was just asking if that was an option. You do
Oh,
what
yeah.
you wish. I apologize.
No. It's just that it seemed as though I'm not sure that everybody was ready to do anything. And I wanted to get a little bit more from Delegate Valentine. Go ahead, Vice Chair Bartlett.
Quick question. I think it might be for Lauren. So I wanted to know why this is in family law section.
The original bill was drafted to the family law section because as it came in, it was trying to add stalking to the list of persons eligible for relief under the family law domestic violence provisions. And that's all been changed now to focus on the peace order part of the code, except for there's still a piece left in family law, which is to expand the use of the permanent protective order on page 3 of the bill. So that's the piece that is still being dealt with under the domestic violence and the family law, but the bulk of the amendments now are moving, have moved to the courts article, which is the peace order statutes.
Mm-hmm.
Gotcha. Okay. And okay, so I get it.
Mm-hmm.
I get that part. Okay. The other question I had maybe is when we talk about, since we're talking about the firearm part now, and now that I'm looking at the protective order, is that 4-506.1 under family law? Is that the protective order, surrender firearms?
That is in 4 dash, bear with me 1 second. I think it's 4 dash. Okay, the part that I was referring to is 4-506 F is the surrender. And then 4-506.1 just sort of outlines the policies for law enforcement after a surrender.
Okay, okay. All right, thank you. Because I just wanted to see, I wanted to see if we could actually do apples to apples.
Mm-hmm. That's what I was trying to.
Yeah. Okay.
Yeah. Okay. Let's come back to this. Anybody else have any other questions? Okay.
Yes, Madam Chair, I have a question.
Go ahead.
If we hold it today, I mean, I think this is a very important bill, and in full disclosure, I'm a co-sponsor, and I would like to see it pass or at least have an up or down vote. So if we hold it today, will we be meeting later this week? Because it is crossover week.
We will be meeting tomorrow if we do so.
Thank you.
Okay. All right. So let's do this. Let's hold this bill, and maybe we'll come back to it at the end of our other bills, or maybe we will again have to resume session, a work session tomorrow on this. Okay, thank you very much. Does anybody have any other questions? I think we do not right now. Thank you very much. And we're going to go on to HB 911. And that is Delegate Valentine's bill, and he happens to be here. And if he could give us a really quick summary of his bill.
Thank you, Madam Chair. Yes, HB 911 simply adds another provision to the peace order statute that has not been previously added. If those on the committee can remember, I had a constituent that testified. She's currently engaged in a situation in Washington County that the visual surveillance portions of peace orders does not apply to her situation. Since we first had our committee hearing on this, I've done some more research with her. It seems that her family had attempted to obtain charges for harassment against the individual who set up a camera next to her barn. That was declined. She has since filed for a peace order in Washington County. That was granted. However, it did not contain the section she asked when she checked for relief to have the camera taken down. That was a temporary hearing. She was supposed to have a final hearing on that Friday. It was postponed because the respondent failed to appear and the judge in the case granted a postponement until this week. So that's kind of where her specific situation is. I just wanted to bring the committee up to speed on that and answer any questions you may have.
Wow, and I see Judge Morrissey here. Okay. Any questions for Judge Morrissey or Judge Delegate Valentine? And Judge Morrissey, did you want to comment at all on this? Oh, you're on mute.
Thank you, Delegate. I appreciate the opportunity. We submitted a comment paper on because we don't disagree with it. We didn't want to oppose it, but you may want to look at Courts and Judicial Proceedings 31505D, which is the relief that can be granted in a peace order. The exclusive jurisdiction of peace orders are with the district court, and typically we don't have injunctive relief we don't have equitable relief in the district court. We're a court of laws. And so the issue may come up that says, do we have the authority to order someone to remove their camera from the building? And I think my judges are concerned that without the legislature telling us to do that, it could be questioned whether we have the authority to do that or not. So if you were to make some type of counteracting or similar type of adjustment to 31505D that said the judge can order the removal of these cameras. It's been an existing problem because of the visual surveillance before we just saw this come in, and we thought we'd bring it to your all's attention.
Thank you very much. Absolutely. And Delegate Valentine, it looks as though you have a question. Or
I did. If Your Honor could just repeat the section he just stated. He said
3-1505D, and that's where the judge is giving the authority of what to do to prevent, to prohibit them from coming to the house, those kind of things. If you added something in there that said removal of a camera, that would give us a bright understanding of what we're entitled to do.
What a judge would be allowed. Okay, what he would be allowed to do.
It's the relief granted section.
Correct.
Okay. Any questions from the committee? Okay. All right. And you said, Delegate Valentine, that your constituent did apply and did receive a peace order.
Did receive a peace order, but could not obtain the relief she was seeking, as the judge just stated.
Right.
That was not included.
Right. Right.
And a final order has not been issued because the respondent failed to appear last week, and they've extended it to this week to try to have the respondent appear.
Okay. Okay. All right. Any other questions? I don't see any. Thank you very much, Delegate Valentine, and thank you very much, Judge Morrissey, for being here. to
Thank you,
answer
folks. You guys
questions.
are a very hardworking subcommittee. Have a great afternoon
Thank you.
and evening.
All right, the last bill we had on our agenda is HB 1310. And I know that Public Defender Zacher and Nina Demelis from the, okay, great. And I also see, okay. All right. Okay. All right, this particular bill actually is to create a Baltimore City Coordinated Youth Violence Review and Response Team. And they're supposed to identify high-risk youth, analyze the root cause and patterns that cause them to become high-risk youth, recommendations that would reduce the number of high-risk youth, connect with appropriate services, defines victim of gun violence, and allows agencies to share information. And there are, I believe, some amendments as well. And if council maybe could talk to us about the amendments.
Sure. I don't have a lot of background on the amendments. I just was given.
Oh, okay. So let me.
I don't know why, you know.
Okay, no problem. So let me do this. I think that Ms. Demelis may have the information on the amendments. Would you go ahead and briefly tell us what those are?
Yes, Madam Chair, thank you. So these amendments are mostly, about 95% of them are to bolster the confidentiality and privacy needs of the team. So for one, it's allowing for police records to be shared with the team, and then further defining that those records are to be kept in a confidential manner. We're adding the definitions for de-identified data and personally identifiable data, because we do discuss them now later on in the amendments to ensure that no identifiable information is being shared outside of the review team itself. We do have one amendment that is not related to privacy or confidentiality, as far as replacing the Secretary of Human Services or designee with the Director of the Baltimore City Department of Social Services or designee. And that is just based upon the work and the resources that the team is looking to provide to youth and their families would be more directly related to social services rather than DHS as a whole. There's an additional amendment that and please let me pause. Let me know, Madam Chair, if I should pause when I see hand raised, or whether I should go on.
No, you can go ahead and finish, and then we'll.
Okay, thank you. So we add additional clarifying language to, oh no.
It's okay, take your time.
Sorry, no, my computer just spaced out, so I couldn't see you for a moment. Okay, sorry about that. I thought I had disconnected. So we're adding language to ensure that we're complying and including language concerning all federal privacy laws related to sharing any youth data. Defining the age range to be for those aged between 7 and through age 21. We are adding the definition of imminent harm rather than the way that it's currently defined in the bill. I do want to note that there is a drafting error in that amendment. Right now, the amendment reads as if all youth ages 7 through 21 would be considered at risk of imminent harm. Items 2 through 4 in that amendment should be it should be that the youth must be age 7 through 21 and also be a victim of violence, witness an act of gun violence, or have a family member who's witnessed an act of gun violence. So just wanted to flag that there is a need for a change there. So then just additional language cleanup concerning ensuring privacy and confidentiality. Adding additional language regarding if a youth is an emancipated youth, that the permission would be requested or consent would be requested from that youth, but that we would also share that information with their parents or guardian as needed. It also, toward the end, provide some additional clarity on the language regarding what's included or not included in that final reporting document, ensuring that not only is all of that information de-identified, but that all members of the review team must review the report before it is able to be shared. And that should cover all of the amendments, and I'm happy to discuss them further. I do want to note that we also have our Deputy City Solicitor, Stephen Salisbury, here to speak to some of the more technical aspects as well.
Okay, thank you very much. All right, Vice Chair Bartlett.
Thank you very much, Madam Chair. I actually don't have a copy of the amendments, but Dina, you did a great job of explaining them. Because I didn't have a copy, there was one little section, one little part I want to make sure I heard correctly. So as far as confidentiality, did I hear you say that I want to know what information can be shared amongst team members about the kids? That's what I want to know, because I thought I heard you say name or something. I just want to make sure that all identifying information is redacted, even with the team members, because I don't see the relevance of a name in order to do the work of the team.
Sure. So between myself and Stephen, we can answer that question. Stephen, do you want to?
I'm happy to jump in. So one thing to keep in mind here is that actually names would be shared among the team members. And the reason for this, a big purpose of the work that's happening here is this is an instance of, key agency stakeholders identifying youth that are at risk, and then saying, actually taking action to potentially head off some conflict. So for example, if you had an incident between two young people and somebody from one of these relevant stakeholder groups could then raise to say, young person X and young person Y were in an incident, maybe there was a shooting or some other act of violence, and it turns out that, they sit next to each other in math class on Tuesday. You need the stakeholders here to be able to share that information to actually do the work of the committee. But that's also why, I think what a lot of the concerns may be is this information is not to be used for law enforcement purposes. It's solely to be used to push and drive support to potential victims of violence. So the statute, both in its original and its amended form, are very clear about not being able to use any of the information. First of all, nobody outside of the identified groups in the legislation is going to have access to this information to begin with. But second of all, any information that is shared here is not to be used for law enforcement purposes. So I did want to just clarify that point, that they will be, in order to facilitate that work, identifying an individual by name, because otherwise they wouldn't be able to sort of, drive the benefits of that collaboration. But it is not to be, there are a number, and we can go through them, but there are a number of restrictions in the way that information would be shared, or, well, wouldn't be shared, but would actually be used. It would not be shared outside of that group.
So I'm looking, again, I don't have the amendments, but I'm looking at the, I wanted to know the members, how many members? You can just give me how many, not the actual, where they're coming from, but how many members?
So there's a number of, I'm just trying to pull up the language, the part of the statute that includes that, because I think that was in the original, but it's.
Oh, I see it now. I got it.
Yeah.
So we got the mayor, the police commissioners, folks like that, the commissioner of health. Okay, I got it. I'm not seeing any members of the public. Is that correct?
Correct.
Okay. All right. Thank you.
And is the MOU with all the members that will be involved? Is that? Okay.
Correct.
Okay.
Yes.
And in that MOU, it talks about the confidentiality and, okay.
Correct.
And their commitment to that. Okay. All right. Okay. And I see Mr. Zacher from the OPD's office. Would you like to comment, or?
Yes, and I apologize for being
Okay.
late. I had a hearing. I wanted to talk about the definition of a youth at risk of imminent harm. I don't know if that topic's been discussed according to the amendments, and I do have a copy. My concern is that it's very broad, and that almost any youth between the ages of 7 and 22 could fall into this category in Baltimore City.
Not to interrupt, but I think and it might have been before you jumped on, but we talked about, I think in that, and we had emailed back and forth, but you had identified a typo. It was actually something that Nina had flagged before us, but that I think would address that. And it's hard to kind of talk through it, but basically just by moving part of that language up a sentence and in front of a colon, what as you, I think, identified in your email correctly, it's not meant to apply to everybody. It's youths that are between 7 and 22 and then have one of those 3 separate criteria.
Right. Yes, I'm not talking about that, although, yeah, that was a drafting error. I'm just talking about this including, it includes 3 categories of people besides age: a witness to gun violence, a victim of gun violence, and a youth who has a family member who's a victim of gun violence. It doesn't define what being a victim of gun violence is. It doesn't define what being a witness to gun violence is. And as for a family member who's a victim of gun violence, if I have a cousin twice removed, am I now suddenly a youth at risk of imminent harm? Kind of doesn't even match what the term imminent means. I feel like this could be used to wrap in every youth in Baltimore for some working group to start gathering information about them. And I'm not sure it would really identify youth we're sort of classifying as high risk.
Well, I can just take a stab at responding to that. I'm not sure if the committee members had concerns of being a victim of gun violence would mean being shot. Being a witness to gun violence would mean seeing somebody be shot. A family member, I think we conventionally would have been thinking about direct, more members of your, direct nuclear family. However, I think we can all imagine scenarios where the example that Mr. Zacher used might sweep in instances if it was a second cousin, or if it was, that we would want to be able to be on the lookout for the same reasons, whether it was a sibling, that we would want to, try to be mindful of the same risks. So again, I'm happy to answer other questions. And Nina, I think, if you want to jump in on anything else more technical, but I just wanted to respond to those kind of more direct questions and offer those clarifications.
And Ms. Themelis, do you have a response to the definition of what a youth at risk is?
So as we have identified it in the amendment, which is a youth between the ages of 7 and 22 who's been a victim of gun violence, witnessed gun violence, or has a family member who's experienced gun violence, the way that the team would know about whether or not a child falls into one of those categories would be based upon self-reporting and awareness of a team member. Typically, it's going to be through the school system where a child might miss some time at school, and then that individual will be connected to services. And I did just want to clarify what the actual purpose of the review team is. The main purpose of the review team is to provide intensive case management to those youth. It is not to draw them into any element of the criminal justice system. It is to provide victim services, mental health services, relocation services, rental and food assistance. And it's really just to provide those wraparound services that we noticed were lacking when the mayor convened youth violence stat beginning last year, and that we've seen a number of times through our child fatality review team review. So I did just want to clarify the purpose of the team is not to pull in children's information for any other purpose other than ensuring that proper services are being provided to them. And the overwhelming majority of referrals for children who would be deemed at risk is based upon self-reporting.
And do you have any idea around how many children you may be talking about? I mean, if it is, you know, as Mr. Zacher mentioned, a very broad group, do you have any idea? Are we talking hundreds, thousand? I mean, what are we possibly talking about? And are you able and ready to accommodate?
So I don't know the full scope of the number of children. We do have an existing MOU that's currently in place among pretty much all of these review team members that is performing this work. We were just looking to codify it so that we would have a longer term and more permanent process for information sharing. So I can get a specific number back to you. I do know that the current capacity of the team has not been exceeded at this point in time. I mean, unfortunately, gun violence is a significant reality for a lot of young people's lives in Baltimore City. So it's likely a larger number than any of us would like. But at this point in time, there's no apprehension as to the team being able to accommodate the need of the work.
Okay, great. Delegate Valentine, you have a question.
Yes, thank you, Madam Chair. My question revolves around the youth being serviced in this program. And the reason I say this is on page 1 and into page 2. My question is this specific to youth that live or incidents that occur inside the city of Baltimore? The reason I ask this is, should an individual go to a neighboring county and get involved in a crime of violence or vice versa? I think when we were on our tour, one of our tours over the off session, a gunshot victim who is a youth comes for treatment into the city, and there's certain mechanisms in place and responses now inside the city that occur. But if you're from a neighboring jurisdiction, it would be new to you and you wouldn't understand why this is occurring. So that is my question. Is this specific to youth in the city? And how that would work in MOUs without agencies and other entities in neighboring counties across this state, and how that would work.
I'll take a first stab and I'll let the deputy solicitor.
Yeah.
This is intended for Baltimore City residents, so it'll be only youth who reside in Baltimore City.
Okay, thank you.
Yeah, Nina's right. I think it's, the idea would be if they're not city, I mean, a big part of this is going to be the schools. If they're not city schools, students, like, or otherwise eligible for other city services, then I think it wouldn't, that wouldn't really be they wouldn't sort of make sense in that process. But yeah, it was intended for Baltimore City youth.
And the only other question I have is, one sentence defines youth as under 21. Another one says between the ages of 7 and under 22, which I think you might have touched on that earlier, and I apologize if I missed it. Which is the correct number?
It is through age 21, so it is up until 22.
Okay. All right. Thank you. Thank you, Madam Chair.
Great. Are there any other questions? Okay.
I have a follow-up.
You have a comment, Mr. Zacher?
A question, if I may.
So usually we don't allow guests to have questions, but if you have a comment about something that has been said, that's fine to open up and allow the committee to have a better understanding of what's before them.
So this is a comment about the additional consent provisions that were placed into the amendment. There's a provision in the amendment which states that if the youth and their parent do not provide consent, then the information regarding the youth may only be shared with the review and response team if there are emergency health and safety circumstances that justify proceeding without the consent required under this paragraph, and all other requirements of law are satisfied. I would comment that I'm not sure what it means to proceed without the consent required. One of the prior speakers spoke about intensive case management. How does one proceed with intensive case management if there's no consent? And it also doesn't define how it's decided whether or not there is an emergency health and safety circumstance. What does that mean? And so I would just comment that consent, when talking about other people's children, seems to be something one should not proceed without. That's all.
Okay, and Mr. Salisbury, just a very quick response, and then I think we're going to move on.
Sure, I would just say, I mean, the idea behind this is always going to be to do this work in conjunction with the families, and it's our expectation, and I think our experience that most of the time families are actually interested in receiving these services and working together. But, you know, if for whatever reason that was not going to be available, or families, you couldn't reach a family, or they, for whatever reason, didn't want to participate, I think, again, thinking back to that original example that I used, where you have two students who might be in the same class who were involved in an incident, you know, there's a necessity not just for those students, but the other students in the class, and I think that's why there is a I think that's why we wanted to, again, while we're always going to be working with, you know, seeking to work with families in these instances, we didn't want to, you know, completely foreclose the possibility of doing some of this collaborative work for just because, again, maybe you have a situation where you're not able to get a hold of a family, or in that situation where maybe a family is not, you know, not interested in working together, and you have a really pressing or potentially urgent situation that we wanted to make sure that that work could still proceed.
Thank you very much. I just have one further question. You mentioned earlier there was a change in the amendment. Can you tell me where that is, where we changed the age again? I'm sorry, I think we probably went over it twice and I still didn't get it either, where that goes.
So the amendment to changing the age is in C. It's 31-111, and it's let's see. Sorry, let me pull up my page here. C1. C1 number I.
Okay. And we just need to change that from to 7 to 21.
So that should remain, that is correct. So in the amendment language, that is correct. I'm not sure if the Office of the Public Defender was referencing a separate area of the bill.
No. You mentioned there was a change that needed to be made in the amendment.
Yes, the one change is in that same section. It is after that number I. There should be either a colon, and 2, 3, and 4 should be indented, because in order to be determined to be at risk of imminent harm, they must fall underneath this age category, and one of the 3 following criteria must be met. It's not intended to apply to all youth who are between ages 7 and 22.
Okay, what page is that on?
In the I
have amendment 143026.
Okay, yes. So that is in that set of amendments. It is on, sorry, going through everything. Okay, so it's on page 4 of that set of amendments.
Okay.
And it would be item number 7.
Okay.
And then where it says toward the bottom of number 7, in line 18, after I insert at least 7 years old and under the age of 22 years old, it would be the language that's in the original bill following that would need to be indented. And then those are the kind of sub portions of.
Okay, so is it changing at least 7 years old and under the age of 21 instead of 22?
So that amendment would stay the same. The language that would need to change would be what's in the existing part of the bill that lays out the additional criteria for who is considered a victim of or at high risk of imminent harm.
Okay, so, because I guess I thought, okay.
I apologize. Yeah. So
the age of 22. Okay. And then adding in, okay, I see what you're saying. Okay. All right. Well, thank you very much. I don't think there are any other questions. Nope, I don't see any hands raised, so thank you very much for joining us today. All right, subcommittee, so we've got amendments and a bill to vote on, HB 1310. And do I have a motion on the amendments and adding the language that was just mentioned to us earlier that needs to be added in?
So move
Excuse
the
me,
amendment.
sorry, Delegate Crutchfield, I'm
Yes.
sorry. I know this
Go
has
ahead.
been explained. I need the sentence read to me because I'm very afraid I'm messing this up.
It's okay.
Yes, is the intention for the new language to read as a full sentence? For purposes of this subsection, a youth is at a high risk of imminent harm if the youth is at least 7 years old and under the age of 22 years and 1, 2, or 3.
Yes.
Okay. Thank you very much.
Move the amendment, Madam Chair.
Okay, second. Is there a second? Is there a second on the amendment?
Second.
Okay. Thank you very much. All right. All those in favor of the amendment, raise your hands. Okay. Anyone opposed? No, I don't think so. Delegate Taylor, are you in favor of the amendment or opposed? Okay. Sorry about that. All right. So now we are on the bill. Do I have a motion for the bill?
Move favorable on the bill, Madam Chair.
And do I have a second?
Second. Okay.
Okay. And do we have any discussion on the bill and the amendment? Okay, none. Then let's go. Oh, Delegate Bartlett.
I find the bill a little scary, but I like the fact that I believe I heard that this is already in practice and we're merely codifying it.
Mm-hmm.
I find it scary because the police commissioner is a part of the response team. And I know the goal is not to involve law enforcement, but police commissioner is part of the response team. And I also would have preferred it if we had used initials as opposed to names. But given the fact that this is already in practice, I didn't ask my question whether or not it's successful, but I'm going to make an assumption that it has been successful given the fact that you want to codify it. So those are my thoughts, and I will probably vote in favor of the bill. I just wanted to wave in my concerns.
Thank you very much, Vice Chair. Appreciate it. Anybody else? Any other discussion on the bill and on the amendment?
Delegate Crutchfield, Madam
Yes.
Chair.
Yes.
I'm sorry, I've been doing double duty and my apologies for being, I can be on camera because I'm.
It's okay. Yes, you're stopped. Please go ahead, Delegate Taylor.
So I heard that this was centric to Baltimore City.
Correct.
What I didn't hear, and maybe, I'm sure because I wasn't fully engaged in the description, is this a pilot of some sort? Is this something that after it is deemed successful can be rolled out across the state? Like, what's the disposition of this project?
So it sounds like this is something that is already in place, and this is just codifying it, and it is very much Baltimore City oriented. I have not heard any discussion about it being something that could be possibly rolled out, but I'm sure any jurisdiction could probably look at it as a model of some kind to use in other places. But that is the
And does the language, I'm sorry to interrupt, does the language in the code allow us to do that? So if, in Prince George's County, we think this is a great idea, do we have to replicate the language, or is it something where it's enabling for us to do?
No, this is not enabling for other jurisdictions. This is just for Baltimore. Okay. But as you know, we're legislators and we can certainly create legislation that we think is something of value for other jurisdictions.
Thank you.
Madam Chair, I know this is a bit unorthodox.
Okay.
But I do want to if it's okay with you, I do want to ask Miss Thanellis if she could elaborate a little bit on the involvement of the police chief that Vice Chair Bartlett raised, because that's concerning to me too.
Okay, yes, you're right. It is unorthodox since we're in the middle of the vote, but it is information I think that is going to be helpful, so I will allow it. So please go ahead.
Sorry.
Thank you, Madam Chair. So the intent of the involvement of the police commissioner is there is the ability of the review team to review police records. None of the information that's shared among review team members is disclosable or could be used in a court of law for any law enforcement purposes. There are penalties prescribed in the bill if any review team member is found to be disclosing that information outside of the review team. But it is to just ensure that as the review team receives information regarding a youth who may have been a witness to violent gun violence or a victim of gun violence, that they may have all of the relevant details surrounding a case. They are not playing a role as far as the connection to services or involvement. They're more so there as a resource partner to provide additional feedback or information from the review team as they're reviewing the case itself that may have brought the child to the review team for consideration.
Thank you, and thank you for your indulgence, Madam Chair.
No problem. All right. Is there any other further discussion on the bill or amendments? Okay, seeing none, let's go ahead and do a roll call vote. Vice Chair Bartlett.
Aye.
Delegate Boucher.
Yes.
Delegate Kaufman.
Aye.
Delegate Pasteur.
Aye.
Delegate Simpson.
Aye.
Delegate Taylor. I'll go ahead. Delegate Taylor. I think was that an aye? Yes. I don't know what happened. I think she's off this way. Anyway, Delegate Tomlinson.
Yes.
Okay. Delegate Valentine.
Yes.
Okay, and I'm also a yes. All right. Thank you so much. Oh, wait a minute. Here she is. Hey, Delegate Taylor.
I'm an aye.
Okay, perfect. All right. One more time for HB 745. We're going to go right back to it. This was the one we left earlier, Delegate Shetty's bill, the one with the amendments. As mentioned earlier, it was always my understanding that the amendments to this bill would shadow, pretty much shadow those of what's in the protective order. And Delegate Valentine raised some concerns about the protective, what was in the peace order regarding firearms. So we wanted to go back, I think, and make sure that language is the same. So that is what I would like to do. And what I'm going to do is ask us to make a motion on an amendment, which was a sponsor's amendment, but we're also going to add in so that we replicate the language from the protective order for firearms, and also it will be the same language in the peace order. So in other words, all the language that is in the sponsor's amendment will describe all of those things that are in the protective order over to the peace order. So that's kind of where we are. And Lauren, am I describing that correctly?
Yes.
Okay. And so I'd like to get a motion on that, if I could.
It's my role today, I guess. So move.
And
Second.
Okay, thank you. And so with that said, is there any discussion on that amendment? Okay, which now should be a motion on the replication of the protective order language into the peace order. So is there any discussion on that? Okay, everybody's cool with it, it looks like. Okay, so I'm going to ask for a hand vote on the amendment. So everybody in favor of the amendment, please raise your hand. Okay. All right, and those opposed? Anybody opposed? Okay, I don't see. Why does my hand keep going up? I'm not sure. Okay. All right, so now on the bill, the amendment. Do I have a motion for the bill and the amendment?
I move favorable.
As amended.
Thank you.
Second.
Thank you. All right. Is there any discussion on the bill? The amendment? Anything? Okay, yes, Delegate Valentine, let's go ahead.
Chair, I just want to clarify that this is only for an allegation or a petition for the stalking provision, no other provision of the peace orders.
That is my understanding. And let's make sure. So council, is that correct?
I did not understand it that way, so I'm sorry. It might.
Okay.
Because the original amendment wasn't really, I may need a minute to understand this a little more thoroughly because it's moving so quickly and I'm not sure to have understood that. Sorry.
Okay, so let's do this. Mr. Coons, you are from Delegate Shetty's office. Is she around?
She just stepped into the leadership meeting. I can see if
Okay.
she can step out to answer the question.
Okay.
1 second, Madam.
All right.
Right, and if I can add a little, the original, if this helps, the original amendment that she had drafted in both the temporary and the final, it authorized the surrender and it wasn't limited to stalking. Then there was a rebuttable presumption provision for a mandatory surrender that did reference stalking. So I'm not exactly sure how she wants to handle this.
Okay.
Delegate Valentine, if I may, could you repeat the question? I could text her the question.
I'm actually going to let Lisa Jordan in.
Okay.
Okay. And she may be able to assist us. Hey, Ms. Jordan. So I don't know if you just heard the question. Delegate Valentine, if you want to repeat it, and maybe we can get some assistance.
With regards to the firearm provision in the peace order, that is only when a petitioner is making a petition under the stalking section and none of the other sections of a peace order? Or is that a new provision for firearm surrender under any of the circumstances of a peace order?
My understanding, Delegate, was that it was under any of the circumstances under a peace order. It was unclear to me, sir, whether your comments were that you wanted to adopt the more stringent provisions that are relative to a temporary protective order, which you probably know, but for the subcommittee's benefit, the use of the firearm against the person who's petitioning, the threat to use a firearm, serious bodily harm to a person, or a threat to cause serious bodily harm. And it may be my confusion, but I had thought that perhaps that was what you were considering, because those are the standards in protective orders. But protective orders are just a blanket prohibition on firearms. And so if you're replicating everything in the protective order into this bill now, it would be any peace order would get rid of all firearms. So as counsel said, this would be a fairly serious policy change.
I know, and that's why I asked. I was under the impression that this only pertained when someone was filing for a peace order under the stalking statute. I did not anticipate it being under all of the other provisions. I was unclear on that, and I'm glad I asked it now.
Okay. Any other questions? Okay. All right.
Delegate, I did
Yes.
just get a thing that Delegate Shetty was thinking it was only for the stalking provisions.
Yeah.
I will say that the advocates would have some concerns about that, because there are other serious violent acts, and in particular, there could even be situations where someone did fall under the protective order. They were brutally sexually harassed. There are all of those really terrible peace order cases in hospitals and things. So I do think that limiting that to just stalking raises some concerns for some of the advocates, certainly for MCASA.
Okay. All right. Well, with that said, I think that what I'd like to do is just go ahead and get a little bit more information to help us all. But you sound like you have another question, Delegate
Just one, Madam Chair. I just wanted to say, when we cover peace orders, we're also covering malicious destruction of properties and trespassing and
Yes.
misdemeanor cases where we're talking about seizing firearms, and I'm concerned about that.
Understood.
Thank you, Madam Chair.
No problem. Thank you for raising the questions. Okay, so what we'll do is we will come back to this. We'll find some time tomorrow. We actually do have a standing meeting time for 3 tomorrow as well. So we'll come back and try to figure this out if we can. Okay. Thank you very much, committee, for hanging in here. We've done this for 2 hours. We got through a lot. So I do appreciate it very much. And I'll see you guys on the floor. Thank you.
Thank you.